Welcome to a research case study presentation by Jennifer Shank Maxwell. This presentation will focus on two U.S. Supreme Court defamation of character cases. The New York Times Company versus Sullivan. According to the Bill of Rights Institute, this is a 1964 landmark freedom of the press case. In March of 1960, the New York Times published a full-page ad for a group, the Committee to Defend Martin Luther King and the Struggle for Freedom in the South, who were seeking funds to help Dr. Martin Luther King with legal matters in Alabama. The ad's headline read, "Heed their rising voices." Most of us know about the strife during the Civil Rights Movement. This ad accused the Montgomery, Alabama police of violence against peaceful protesters. Some of the accusations were true, but many were misleading and over-exaggerated, or just plain false. L.B. Sullivan was one of 3 commissioners in Montgomery, Alabama at the time. As commissioner, he was in charge of public safety. Even though Sullivan was not named specifically in the ad, he felt it was a comment on him as well. Because he was ultimately the head of the department, he either allowed or encouraged the alleged activities, or as a poor leader, he had no control. Sullivan requested a retraction, but the New York Times response was a question asking why he felt he was being defamed. Sullivan's response was to file a defamation lawsuit in the courts of Alabama against the New York Times. He also sued the 4 black ministers named in the ad. In the New York Times case, the Alabama courts awarded Sullivan $500,000. To determine if a statement is defamatory, there are certain elements that must be met. The statement must be proven as false. Negative opinions do not qualify as false statements, since opinions cannot be proven or disproven, only changed. The statement must be public or published, meaning heard or read by someone other than the defamed person and not including the author. The defamed person must be named or by description be beyond doubt who the intended subject is of the statement. There must be damage or injury to the defamed person by reputation or in his livelihood. The fault that defamation occurs lies with the author of the statement. This means the author wrote it either with actual malice or with negligence in determining if the statement was false. This case went before the U.S. Supreme Court for reasons involving the First and 14th Amendments. Sullivan is considered a public official, therefore his actions are subject to public scrutiny. His burden of proof of libel requires actual malice, which was absent in the Alabama case since the judge there did not require it. The 14th Amendment prohibits states from violating the First Amendment freedom of press, which holds publications exempt from libel unless malice or reckless disregard can be proven. The Supreme Court determined there was no malicious intent or reckless disregard, and a publication cannot be exempt from requirement because the statement generated money in the form of an ad. They reversed and remanded the state's findings. Gertz versus Welch. In this case, the U.S. Supreme Court defines the difference between public and private individuals where proof of defamation is concerned. Elmer Gertz was hired by the family of Ronald Nelson, a child victim in a 1968 police shooting, to sue the officer Richard Nuccio for civil damages related to that shooting. Robert Welch headed the John Birch Society, who in turn is the publisher of American Opinion magazine. The magazine commissioned an article about the Nuccio case and hired someone they deemed reliable. The article was published with the title, Frame Up Richard Nuccio and the War on Police. The article accused Gertz of participating in the frame-up, but Gertz was not part of that trial. It also stated Gertz was a communist organizer and called him a Leninist and communist fronter, and that he had a criminal record. Gertz was a trial lawyer. Although it was argued that he could be considered a public figure, it was determined he was not. He led a quiet life, out of the public eye, except when attending court. He kept to himself and refused to talk to the press about his own lawsuit against Welsh. Originally, the state of Illinois awarded Gertz $50,000, but reversed this, stating that the New York Times versus Sullivan case should apply. The U.S. Supreme Court addressed the issues concerning private versus public persons and what their burden of proof should be. Eventually, Gertz was awarded $400,000. The American Opinion hired a regular contributor to write the article concerning Gertz. The editor made no effort to check the facts for himself, but included an introduction stating the author had done his research. For many years, there had been a war on communism. To be called a communist or in any way associated with communism would cause a person to be shunned and sometimes even attacked. This in itself would cause people not to hire him as a lawyer, but there was also the added accusation of a criminal record. A criminal record accusation could cause a bar association investigation and possibly get him disbarred. The article should have been read to determine all the possible defamatory comments. Then each of those comments should have had the facts checked. Any false facts should have been removed. However, this would have left the article almost non-existent. Indiana has 4 elements of defamation: a communication with defamatory imputation, malice, publication, and damages. Defamation per se includes accusations of criminal conduct, a loathsome disease, misconduct in a person's profession or occupation, or sexual misconduct. Indiana requires actual malice. If the statements are newsworthy or involve matters of public concern, even if the person is a private figure, it must be proven actual malice. Privileges and defenses include substantial truth, opinion, and fair comment and fair privileges, and fair reporting privileges. Under Section 230 of the Communications Decency Act, if someone other than you, your employee, or someone acting under your direction posts a defamatory statement to your blog or website, you cannot be held accountable. But one of the biggest differences in Indiana statute is the statute of limitations for defamation. The state recognizes the 2-year limit, but starts the clock ticking when the damage of the statement is susceptible of assertion rather than when the statement was published. There are many lessons to be had from both these cases. Check your emotions at the door. Know the person about whom you are writing and their rights. Know your own rights. Get the facts. And do not make stuff up.